What's involved in doing a basic probate in Arizona? Hi, I'm Attorney Paul Deloughery, and there are 10 steps, so let's go through them. First, you should figure out if there's a will. So you need to look around for important documents and see if there's a will. Commonly, if it was done by a estate planning attorney, it would be in a binder, and it'll say estate planning documents or something like that, so it'll be pretty obvious. So you're looking for the original will. Next, you're trying to figure out who the nominated personal representative should be. That's assuming there's a will. If there is no will, then you need to figure out who can serve, who's willing to serve as personal representative. And then next, you need to ask if the estate, if the situation will qualify for what's called a small estate affidavit. In Arizona and in every state, there are certain thresholds, and if the amount of personal property is under, minus liens and encumbrances is under a certain amount, or if the real estate minus liens and encumbrances is under a certain amount, then you can transfer that property just using an affidavit. Now, that's not always possible. I'm saying that it may be possible, and so you should think about it. Here in Arizona, the amount for, currently, this is 2023, the amount for personal property minus liens and encumbrances, so in other words, $50,000 fancy pickup with a $25,000 loan on it still, so that's $25,000. Amounts in bank accounts, you add those up, and other personal property. If that's less than $75,000, then it might be possible to use what I'm referring to as a small estate affidavit. Next, number 2, look for important financial documents. This might be, again, like I said before, the will. You're looking for an original will. Photocopy, sometimes you can work with a photocopy of a will, but it definitely is a lot harder. So you're looking for the original. And death certificate. You're trying to figure out if there's a death certificate already or to get one. You're looking for trust documents, if there are trust documents, and then financial documents, bank accounts, tax returns, anything financial related. Third, if you need to go to court and file a probate, then you need the necessary documents to do that. Here in Arizona, the way it's set out is if certain conditions are met, you can do it by what's called an application. That means you just go to the filing counter and they process things and you get back letters of personal representative in return. And that's what you can take to the bank and get access to bank accounts, record, sell the house, and all that kind of stuff. Or if there's an issue, if maybe there's conflict in the family, or you don't have the original will, or you're not sure who should be appointed as personal representative, any number of things like that, then you have to do what's called a formal petition. So it's a petition that you file with the court. There's a hearing, the judge or probate commissioner hears it, makes rulings, and then assuming everything goes right, at the end of the day, I don't mean day, after several weeks, if everything goes well, you can then be appointed as personal representative and go and get letters, and then you can do what I was saying, get the bank account, sell the house, all of that. Fourth, you have to notify people. So after you've gone to court, someone is appointed, maybe it's you, got appointed as personal representative, then you need to notify the heirs, notify the people named in the will, whatever the case may be, notify the necessary people, and that's figuring out who that is more complicated than I can cover in this video, but you notify the necessary people. Then you publish notice to creditors, and you mail a notice to creditors to all of the known creditors. So step 4 is notifying the relevant people. 5, inventory and appraisement. This is basically where you catalog or inventory what the assets are, and you come up with a valuation of those. You present that or provide that within a certain period of time. Here in Arizona, it's 90 days. Within 90 days of being appointed as personal representative. So you provide that to all of the to the heirs and relevant people. Now, the Arizona statute, and I think this is a common situation in, as far as I know, all states, doesn't really clarify what an inventory means. For example, if you have a situation where the deceased person owned 1,000 collectible dolls and a whole bunch of collectible stamps, do you just put stamps and dolls as two different lines? Dolls value, I don't know, $15,000. Stamps value $200 or whatever. Okay, that wasn't valuable, because I've seen where stamps can be a lot more valuable. Do you do that, or do you actually list out each doll? You know, porcelain, blah 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 blah, vintage 1857. Porcelain, blah blah blah. You know, do you do that? There are lots of heated arguments among heirs about this, and unfortunately the law is just not clear. So the best thing is talk to an attorney and get advice and do what's appropriate for the situation. Sixth, pay valid claims, debts, and taxes. And now there's a whole process for handling claims. You might have a question about whether a claim is legitimate. There might be some vague $15,000 credit card bill. You don't know if your deceased person actually ran that, or was it fraudulently done or something like that. So you need to, I guess, get the paperwork if you question it. And there's a whole process. I'm not going to go into that in this video, but there's a process for figuring out what are legitimate debts, what are not legitimate debts. And there's also an order in which creditors and taxes and everything get paid. So usually, here, let me talk about Arizona. So in Arizona, first of all, you have cost of administration. Then you have the final health care costs and funeral costs and so on. And there's a certain order, a pecking order, in which people have to get paid and creditors have to get paid. And then at the end of the day, hopefully you have some money left over, and that's then what you can distribute to the, to the heirs, to the people entitled. 7, you have to actually manage the estate. Now, this can be more complicated than it sounds. For example, if there's a business, then you need to maintain the business so that you can sell it. And it's not just a matter of sitting back and watching it, because the employees might be leaving, customers might be leaving. So that's a real touchy situation. If there's a house, you need to make sure that homeless people are not breaking in. I've had that before, breaking in and stealing copper pipe and so on. Make sure that the utilities are still on, so the plants are being watered. Again, I'm in Arizona, very important. Anyway, just make sure that things are being maintained so that then you can sell things as necessary. And then this actually kind of bleeds into the next point, which is 8, distributing the remaining assets. Now, really get some advice in all of this area. This is where people really mess up. I've seen so many mistakes happen. Commingling money, for example, okay, it's work in order to open a bank account for the estate. You have to go to the bank, show the letters, the bank has to look at it. Sometimes they give you a hard time, but that's the proper thing to do. It's not proper to take money from the sale of whatever, the house or the car or whatever, and put it into your personal account and just assume you're going to be able to keep track of it. Don't do that, okay? No commingling. There's so many little things here. But anyway, this is a checklist. This isn't, the point of this video is not to get into all the details. So number 8 is distributing assets. One little point about that. In Arizona, there is a presumption that personal property should be distributed in kind, meaning, okay, the $15,000 of collectible dolls. You ask the heirs, hey, do you want your whatever percentage, 1/5 or whatever it happens to be, share of collectible dolls? If not, then we're going to sell those, okay? But they're entitled to that. The purpose of this is there might be family heirlooms. There might be I don't know, a 200-year-old American flag. Had a situation like that. There might be a quilt that Betsy Ross actually made. Had a situation like that. Anyway, things like that. Yes, you probably want, or your clients probably want to. I didn't mean clients. You probably want to keep that in your family. You know, if it's been in the family for 200 years or for so on, for a long time, or it belonged to your grandparents or something, yeah, try to keep that in the family. So that's why that provision in the statute is in place. But definitely get some help with this area because it's really easy to mess up. Step 9 involves a final accounting. Now this is the part where again, a lot of disputes can happen. So in Arizona, what we typically do is we have a proposal for distribution. We actually provide an accounting to the people, to the heirs, people listed in the will, and this is what we started with, this is what it sold for or got distributed out at or something like that, and these were all the expenses, and here's what we have left. And then, so that's the final accounting. Then you provide what's called a proposal for distribution. And so, at the end of the day, there's this amount of money left. You divide that by however many people there are, and you, Mr. or Mrs. Heir, you're entitled to this much money. And then under the statute, if they do not object within 30 days, then that's deemed to have been accepted, and then you can send the check out safely. Okay, so that's step 9. And then step 10 is filing a closing statement with the court. Now this is assuming you may not have a step 10. This is assuming you had to actually go to the court and do a probate. Because the court is, they're typically not going to be micromanaging this process. I mean, it's a very rare situation when a court is going to be supervising the personal representative and making sure this got sold and this happened and that happened. No, the probate commissioner does not want to do that. But they do have a system in place where if a probate has been open for 2 years and there's no closing statement filed, they'll send out a threatening letter to you, the personal representative, saying, we haven't heard from you, it's been 10 years, here's a deadline to either report to the court or file a closing statement. So that's what you have to do. If you have any questions, give us a call at 602-443-4888, and I'd love to hear from you.